The underlying dispute concerns President Trump's highly controversial and constitutionally dubious executive order restricting birthright citizenship.
The challengers to Colorado's law succeed. That's going to raise difficult questions about how much that erodes the power of states to regulate professions and licensed professionals.
The court held that there was not a violation of equal protection when Tennessee forbade minors from receiving puberty blockers, cases involving President Trump's efforts to fire people, funding cutoffs, and a lot of cases involving the president's authority with respect to immigration.
Welcome, and thank you for joining us today for another Justia webinar. My name is Nina, and I'll be the moderator for today. Now, to kick things off, I want to go ahead and introduce our speakers, Vikram, Amar, and Michael Dorf. Vikram Amar is a distinguished professor of law at UC Davis and was previously the dean and a professor of law at the University of Illinois College of Law from 2015 to 2023. Amar has also taught law at Berkeley School of Law, Hastings College of Law, and now known as UC Law, and UCLA School of Law. Amar is one of the most eminent and frequently cited authorities in constitutional law, federal courts, and civil procedure. He has also written several books and more than 60 articles on leading law reviews. He's the co-author of the upcoming revised multi-volume treatise on constitutional law, pioneered by Ron Rotunda and John Nowak. Michael C. Dorf teaches constitutional law, federal courts, and related subjects at Cornell Law School. He has authored or co-authored 6 books and over 100 scholarly articles and essays for law journals and peer-reviewed science and social science journals. He also writes a bi-weekly column for Verdict and publishes a popular blog, Dorf on Law, dorfonlaw.org, and has received his undergraduate and law degrees from Harvard. The webinar presentation that you're about to watch will be approximately 1 hour. If you have any questions and if there's time for us to take them, you can always submit them through the Q&A button in the control panel at the bottom of your screen. Now, without further ado, here are Vic and Mike to discuss previewing the 2025-2026 Supreme Court term, breaking down this year's docket.
Thanks very much, Nina, and good to be with Vic again. We have made this a bit of a habit each year at the end of the term and the beginning of the new term. It feels like just yesterday we did the review of last year's term. So our plan is we're each going to say a little bit by way of overview, and then we've divided up some of the most prominent cases, which we will go through. Each of us makes a few comments on those and then comments on the others' comments, and that'll, before you know it, take us to the end of the hour. So let's get right into it. I want to say a few words about last term, and I'm going to highlight 3 cases, 2 of which will turn out to be very important for making sense of what's coming up in the current term. And I should say, when we say coming up, this isn't exactly entirely a preview because Monday was the beginning of the court's new term. So it's sort of a preview while we've already gotten started. And so one of the cases I'm going to talk about was actually argued already yesterday. Okay, so the cases I want to highlight from last term are Trump v. Casa, the Scrimeti case, and Mahmoud against Taylor. So Trump v. Casa was a case that the underlying dispute concerns President Trump's highly controversial and constitutionally dubious executive order restricting birthright citizenship. That issue has come back to the docket, and Vic's going to talk about it a little bit later. But the issue in Trump v. Casa was restricted to the remedial authority of federal district judges. The court in that case essentially said that a federal district judge may not grant a universal injunction, meaning an injunction that binds non-parties, except in the limited circumstances where doing so is necessary to provide complete relief to the existing parties. And as a result, that somewhat curtailed what had been the practice among a lot of district judges. This is an issue that's been bubbling around in academic literature and in the lower courts for the better part of a decade, but the court finally put its foot down, and we'll see that that might have some implications for some of the remedial questions in two cases I'm going to talk about a little bit later in the hour concerning President Trump's effort to fire members of independent agencies. The Scrimeti case involved Tennessee's ban on gender-affirming care. The court held that there was not a violation of equal protection when Tennessee forbade minors from receiving puberty blockers or hormone therapy to aid in their transitions. And in the process, didn't reach what many of us thought was sort of the important question of whether laws that discriminate on the basis of transgender status are subject to heightened scrutiny in virtue of discriminating on the basis of transgender status, or in virtue of the fact that they are, in some sense, sex discriminatory. The court said, in reasoning that I think Vic and I found not especially persuasive, that these laws didn't actually discriminate. Tennessee's law didn't actually discriminate on the basis of sex or transgender status, and so it didn't have to reach that question. And then it found that the law was rational, which is the lowest level of scrutiny. I'll talk more about Scrimeti when I get to talking a little bit later in the hour about two cases on the current docket involving bans on transgender female athletes participating in girls' and women's sports. Final case I wanted to tee up was a case called Mahmoud against Taylor. I don't have any direct implications of this case for the current term. It's another culture war case, though. In this case, the court held that parents who object to what we might think of as LGBTQ plus inclusive curricula are entitled to have their children opt out of those classes. And this has the potential for enormous disruption, I think, of public education, or will have the other possible effect of making schools very timid about having curricula, including just books in their library and occasional lessons that could be objected to by people on religious grounds. One other thing I want to say by way of introduction is that although the last term technically ended at the end of June, and this one just began this week, in a sense, the court hasn't been on a break. That's always true that the court is available over the summer, but it was especially true this past summer because of the number of cases that the court had on its emergency docket, cases involving President Trump's efforts to fire people, funding cutoffs, and a lot of cases involving the president's authority with respect to immigration. I'll talk more a bit about one of those cases, a case called Trump v. Wilcox, when I get to the cases involving the independent agencies. But for now, I think I'll leave it at that and turn it over to Vic.
Thanks, Mike. And thank you, Nina and Justia, for hosting this event. Let me just build on what Mike said about some of the cases from last term. I might qualify one way he characterized the CASA case involving universal injunctions. I might describe universal injunctions not as injunctions that bind non-parties, but that rather seek to protect non-parties against parties who are in the case, and in these instances, the United States government. So it's really about whether the judicial decree can go beyond protecting the particular plaintiff as against the defendant to try to afford protection to non-plaintiffs. And the court said, no, that's inconsistent with kind of equity practice and tradition.
Yeah, that's a friendly amendment, just so we're clear.
Good. And Mike's mention of Mahmoud, I think, is helpful. And Mike's right that it doesn't directly have implications for any of the cases that we know of on the current docket, except that one of the cases Mike's going to talk about that was argued yesterday involving Colorado's ban on conversion therapy, to me, raises the same big meta-constitutional problem in the First Amendment area of line drawing. And Mahmoud versus Taylor illustrates that the court doesn't seem scared of recognizing a First Amendment right, even though it has the potential to really disrupt regulatory authority in a way that's going to require some lines to be drawn. So too in the conversion therapy case, if, as appears and as Mike will discuss, the challengers to Colorado's law succeed, that's going to raise difficult questions about how how much that erodes the power of states to regulate professions and licensed professionals who happen to engage in speech in their work. A couple of other points about the current term. One is that there's still a lot of cases to come, as is true for last term. The court might be holding a little bit of its fire or powder because it's expecting there to be other big cases that it needs to grant cert on, including the Birthright citizenship case that they technically haven't granted a merits review on, but that I expect them to. But also, as is true from last year, they probably think that the president isn't done issuing kind of contentious and ambitious executive orders, many of which will require so-called emergency or interim relief or shadow docket resolutions the way they did in many cases last term. Which leads me to the final introductory remark. A lot of media have looked at some of the statistics from last term and pointed to a lot of these interim relief shadow docket matters and say that President Trump is winning a lot of the time, and this court is kind of favoring President Trump, or at least is sympathetic to his legal positions. And I'm not going to rule out the possibility that this court ends up looking like it's very deferential to the president, but I would quickly point out that the cases that the Solicitor General, John Sauer, who represents the United States in the Supreme Court, sought to have reviewed in the Supreme Court on an emergency or interim relief basis were a self-selected, cherry-picked group of cases in which the federal district judges that had enjoined President Trump might have been out of their skis a little bit more than the average case. So there are hundreds of cases in which courts enjoined the administration that did not get to the Supreme Court. So the question is, what's the relevant denominator? Is it 15 out of 20 cases that went there that he won, or is it 15 out of 150 cases that have been the subject of litigation and some kind of judicial decree? I liken it to, I was, as Nina mentioned, I was dean at Illinois Law School for 8 years. And Illinois, like a lot of big sports programs, will schedule cupcakes at the beginning of its football season. So Illinois will play, Western Michigan and Western Illinois and Kennesaw State. All fine schools, I'm sure, but their football programs aren't Big Ten caliber. And Illinois would go 3-0, and all my friends would say, "Oh, we're really good. We're 3-0." And I say, you haven't played anybody yet. How can you say that?" So Trump, the president, is going to have to start to play some more real games at the court now in cases where it's not as likely he will win. I would say the executive order on birthright citizenship is one. The tariff case is another. That the Lisa Cook Federal Reserve case is a third. And I'm not saying that he'll lose all three of those. I think he should lose all three of those. But it's going to get the going is going to get tougher now that the cases aren't cherry picked the way they were last year. So let me back to Mike to start introducing some of the big cases on the docket this term.
Okay, great. So just to be clear from my little intervention there that that Vic's right. I misspoke when I was talking about costs. So what I meant to say was binding the government with respect to non-parties. So we're on the same page here. That wasn't a disagreement. It was just me making a little error. Okay, so the first batch of cases that I'm going to talk about are cases involving the president's efforts to remove officials from positions in which they are supposed to have, by statute, protection against a removal by the president, except for good cause. And to tee these up, I think it would be helpful if I began back in the 20th century with a case called Humphrey's Executor against the United States, in which the Supreme Court upheld what is known as a good cause removal protection for a federal trade commissioner. This is during the New Deal. And the court said that, yes, Congress can insulate from direct presidential removal certain members of what we have come to understand as independent agencies within the government. Humphrey's Executor had to distinguish an earlier case called United States against Myers, in which the court had invalidated a removal restriction for a so-called postmaster first class. And that's sort of where things stood until the Roberts Court got its hands on these doctrines And over the last decade and a half, it's become clear that the Roberts Court is unhappy with the regime of Humphrey's executor, applying what's sometimes known as the unitary executive theory or some offshoots of it. The court has narrowly read Humphrey's executor. So, for example, in one case, they said, well, you can have good cause removal protection, but you can't have two layers of good cause removal protection. In another case, they said you can have good cause removal protection for one member of a multi-member commission, but not for somebody who heads an entire agency. And so they've been gradually narrowing Humphrey's executor, and there's very, very good reason to think that they will overrule it this term in a case called Trump against Slaughter. The reason I say that is because the court effectively didn't apply Humphrey's executor earlier this year in an emergency docket case called Trump against Wilcox, which was actually two cases involving removal of members of the National Labor Relations Board and the Merit Systems Protection Board, each of whom also had what is essentially good cause removal protection. The president nonetheless said, I want to remove these Democratic appointees because they don't align with my policy goals. Lower courts enjoined those removals, and then the Supreme Court, on its emergency docket, so technically only a preliminary ruling, said that actually we think that the government, the balance of the equities and the likelihood of success in the merits and all the usual factors involved in interim relief point in favor of the government. In the Wilcox case, Justice Kagan, writing for the dissenters, and these cases split along partisan ideological lines, Justice Kagan called the majority to task for not even mentioning Humphrey's executor in the course of sort of the drive-by overruling. So one case that presents that issue very, very clearly on the court's sub-merits docket is Trump v. Slaughter, because Slaughter is actually a member of the FTC, the very same agency that was involved in Humphrey's executor. There, too, the lower courts enjoined her removal, and the Supreme Court on an interim basis stayed that, and then granted certiorari for its merits docket on two questions. And I'll read the questions because I think they're both important. The first question is whether the statutory removal protections for members of the FTC violate the separation of powers, and if so, whether Humphrey's executor against the United States should be overruled. So that's very straightforward. And then the second question is whether a federal court may prevent a person's removal from public office either through relief at equity or at law. I think that given what the court did in Wilcox, notwithstanding its arising in an emergency posture, that the answer to the first question is essentially a foregone conclusion. But I think it's very, very likely that the Supreme Court will in fact find that this kind of removal protection does violate the separation of powers and will deliver the coup de grace to Humphrey's executor. That will mean, if the court does that, that it's not going to have occasion to answer the second question on whether a federal court can prevent removal through relief at equity or at law, at least not in that case, that is to say, in the Slaughter case. But there is another case on the court's docket where I think that question could be important, and that's Trump v. Cook. That's the case involving the president's effort to remove Lisa Cook from the Federal Reserve Board of Governors. Now, in the Wilcox case, the Supreme Court, as it had done in one earlier case that it cited, suggested that the Federal Reserve might be different from most other independent agencies. And it gave two distinctions. One distinction is they said that it's a sort of public-private partnership. The Fed is not entirely a government entity. And the other is they said that it's sort of in the tradition of the first and second banks of the United States. And so it might be validated by sort of history and tradition in the way that the Roberts Court has turned to history and tradition in many other areas. I think underlying both of those is also a policy concern that the court shares with most economists, which is that if the Federal Reserve, the central bank, is too beholden to elected officials, then you run the risk of very loose monetary policy which President Trump wants, right? He wants the Fed to lower interest rates, not just a quarter point at a time, but a full 2 points or whatever it is, right? You run the risk of very loose monetary policy, which could be very, bad for the economy in the long run. It spurs activity in the short run, but could lead to something like hyperinflation, which is catastrophic. And so I think the court is highly motivated and has a rationale in mind by which to distinguish the Fed. Now, interestingly, in the Cook case, the president has not asserted that the restrictions on his removal authority are unconstitutional. Rather, President Trump purported to fire Lisa Cook for cause, namely this idea that when she was applying for mortgages for a couple of houses a number of years ago, she listed 2 of them as her primary residence, whereas obviously a person can only have one primary residence. Now, Cook argues that that was pretextual. And in the lower court, the ruling was the district court initially ruled that the president couldn't fire somebody for cause based on conduct that happened before they were appointed. The appeals court didn't rely on that part of the decision. The appeals court instead said, well, this is just a violation of due process. If you have good cause removal protection, the president has to give you a hearing, some kind of a way of determining whether you've done the thing that allegedly amounts to good cause. So the court thought that this was a violation of what we sometimes call procedural due process. Now, remember that question I said that's at issue in the Slaughter case that probably won't be decided there. That could play a role in the Cook case because the question then is, let's assume you think that she was fired without adequate process. There's a remedial question of whether a district court can order the president to rehire her, or in this case, since she hasn't actually left yet, to keep her on. Humphrey's executor, as the name suggests, right, arose after Humphrey was dead, right? It's the executor of his estate who was suing for his money that was owed. You might distinguish this. And this is how last term's case, in the last term's CASA case, might be relevant, because the core rationale of Justice Barrett's opinion in the CASA case was that federal district courts only have the equity powers that Congress has either explicitly granted them or that they traditionally exercised at the founding. And so there's a debate in each of these cases about whether federal district courts have the authority to reinstate or keep in power members of independent commissions or other agencies of government whom the president has purported to fire. I'll stop there and turn it over to Vic.
Great. So let me just say a word about Cook. 2 words about Cook. First, if the court in Wilcox is serious that the Fed is different and Congress should be able to insulate it politically, then I think there are 2 things that follow from that. One is that the concept of cause, both procedurally and substantively, can't be too thin. That is to say, a president can't evade that independence, that congressionally conferred and permissible independence, simply by watering down what constitutes cause, either as a substantive matter or as a procedural matter. Although I agree with Mike's implicit suggestion that the district court's absolute reasoning that you could never be fired for something that happened before you took office is probably too broad. That's probably not a sustainable rule of thumb. But whether this particular conduct that predated appointment is sufficiently grave and sufficiently well established as to constitute cause, I think the court can't really answer that in too flimsy a way without it kind of undermining the independence it seemed to recognize in Wilcox. Second, and relatedly, I think as a remedial matter, reinstatement, although I know there's not a lot of kind of precedent for reinstatement or maintenance in office of high-level executive officials, but again, if the independence is to be real, then giving Lisa Cook her salary and benefits for the term that she was supposed to have doesn't really confer independence on the Fed, because there's a vacancy that Trump gets to fill, and the Senate, of course, is going to do whatever Trump wants. So I think if we take the concept of independence meaningfully, that has remedial implications. And I will say that in a lot of other settings, again, not high level cabinet level or similar positions, because we just don't have precedent. But as a matter of general equity practice, if Mike or I lost our tenured professorship for illegitimate reasons, a federal court could award us damages, but it could easily reinstate us. That's a very common reinstatement is a very common equitable remedy when someone loses a job. And even from Lisa Cook's perspective, not the nation's perspective, getting her pay is not quite the same as being able to serve on the Fed with all the prestige and influence that brings with it. So let me then introduce another case that we talked about briefly, and that's the Birthright citizenship case. CASA, as Mike mentioned, involved only the universal injunction aspect of that dispute. I was disappointed that the majority of the court, the conservatives, did not indicate or signal their discomfort with the merits of, as Mike put it, a very dubious dubious executive order that the president issued his first day in office. But now Solicitor General Sauer has asked the Supreme Court a few weeks ago to take up the merits and do so, in fact, on an expedited basis. I guess he didn't ask for it to be an expedited basis. So I fully expect the court to grant cert in this case, set it for argument maybe in early 2026, and then decide it by the end of June. So let's talk about the merits of this order that are likely to be one of, if not the most important rulings of the term. The order, in short, says under the 14th Amendment, whose text reads, "Any person born in the United States and subject to the jurisdiction thereof is a citizen of the United States." I stripped it down, but that's the essence. Any person born in the United States and subject to the jurisdiction thereof is a citizen of the United States. The order says that to qualify for birthright citizenship on account of being born in the United States, you not only have to be born here in the U.S., but you also have to have at least one parent who's either a citizen or a permanent resident alien, a parent who's either a citizen or here on a permanent basis. So if both your parents, or if neither of your parents is here legally or permanently, you're not a citizen even though you were born here. That's the essence of the order. Now, the administration has taken the position it wants to apply this order only prospectively to children born after the effective date of the order. But that's not something that's a part of the constitutional theory about what the order means. In other words, the prospective application of the order is a matter of executive or legislative grace. There's nothing, if the Trump administration is right about the meaning of Section 1 of the 14th Amendment, there's nothing inherent that would prevent the administration from applying this executive order to people who are already born here and who've taken their citizenship for granted for years or decades or lifetimes. And notice that in theory, the order has the potential to unravel the citizenship expectations of scores of millions of Americans. Let me give you an example. Okay, let's say Mike's grandfather came from England. He was a scientist. He was invited here to work on the Manhattan Project during World War II, the atomic bomb. So he comes to America. He's a prominent physicist. I think Mike said that he majored in physics at Harvard. So I'm going to use that. So in this tradition, his grandfather comes and works in New Mexico on the Manhattan Project, meets a lovely scientist from France. They get married. And at the time they're married, neither of them is citizens. They're here only on a 5-year scientific visa. They have a child, Mike's father. And Mike's grandparents later go on to become citizens, but at the time of his father's birth, neither of them was here on a permanent basis. Neither was a citizen or a permanent resident alien. Now, Mike's father thought he was a citizen by virtue of being born here. He could have become a naturalized citizen very easily, but no one ever thought he needed to because everyone took for granted he was a citizen. But he's kind of a persona non grata. He then marries a person from another country and has Mike born here. And then Mike's not entitled to birthright citizenship because neither of his parents was either a citizen or a permanent resident alien, and he could be decitizenized by virtue of this order under those hypothetical facts. So the question then is this executive order's understanding of the first sentence of the 14th Amendment plausible? Any person born in the United States, relatively straightforward, and subject to the jurisdiction thereof. That's where all the action is. Today, we would say subject to the jurisdiction thereof means subject to the regulatory authority thereof, people who have to obey American laws. And persons born to unlawfully present parents or temporarily present parents, they have to obey. They don't have an immunity. They don't have a get us out of jail free card. They have to obey American laws. If not, they're punished. If they commit a armed robbery, they go to jail. So modernly, we would say that the text is quite clear. It turns out at the time, as far as I can tell, all the statutes in that era that used the word jurisdiction used it in that similar sense, the power of government to apply law and authority to individuals. Now, the alternate reading, which really runs up against not just the textual understanding of jurisdiction, but the English common law that we inherited that conferred a political belonging based on where you're born, law of the soil rather than law of the blood, as was true on the continent in places like France. And the legislative history of Section 1 of the 14th Amendment and its predecessor, the Civil Rights Act of 1866, and the statements by the members of the Lincoln administration, both before and after the 14th Amendment, as well as the U.S. Supreme Court in an 1890s case, Wong Kim Ark. All of that goes against the administration. So the administration's theory is that subject to the jurisdiction thereof requires that the parents of the person born in the United States be allegiant to the United States as demonstrated by some kind of long-term presence. That the key is whether the parents are actually loyal to the United States, and for that they need to be citizens or permanent resident aliens, and then and only then are their kids born here citizens. Number of problems with that reading. Most importantly, the text of the 14th Amendment does not focus on the parents. It doesn't say any person born in the United States to parents who ... It says any person born in the United States and subject to the jurisdiction thereof. No mention of anything relating to the parents. Second, many of the people that everyone agrees were made citizens by the 14th Amendment, that is, enslaved persons, were themselves here illegally in the sense that their parents were imported as slaves after slave importation was made illegal. So some of the people who were born in the United States who were made citizens of by virtue of the 14th Amendment were children of persons who were not here lawfully by virtue. Now, granted, they didn't choose to come here unlawfully. They were brought here unlawfully, but legal presence can't be the touchstone, nor can allegiance. Why? Because during the time the 14th Amendment was being considered, there was a proposal to strip rebels, Confederate rebels, of their citizenship, and proponents of the 14th Amendment says, no, we can't do that. They were born here, and under the amendment that we just proposed for ratification, as long as they were born here and subject to the power of the United States, they are citizens. We can't strip them, much less strip their kids. And finally, the scope of the order does not track the theory under which the administration is proceeding. If the theory is grounded on the idea that subject to the jurisdiction thereof involves some inquiry into the allegiance of the parents, well, a permanent resident alien is not allegiant to the United States. There's another term for a permanent resident alien. That's citizen of another country. We know that because we're deporting a lot of permanent resident aliens because they're citizens of other countries and we don't like what they're doing here. So the order itself doesn't even track the cockamamie theory that they put together. And for a court that in Dobbs says you can't make stuff up, you got to look at the text and the history and the structure of the Constitution. It would be astonishing to me for this court to embrace this reading of Section 1 of the 14th Amendment to say nothing of the congressional statutes that Trump has ignored in unilaterally redefining birthright citizenship, when those statutes seem to embrace the conventional understanding of what birthright citizenship means. So I expect the administration to lose this, hopefully lopsidedly, hopefully unanimously, but at least 8-1, 7-2, if not 9-0. So let me stop there, Mike, and then give you a chance to weigh in on that and mention a couple of other cases, and then I'll come back and talk about Calais.
Okay, so just quickly, all of my grandparents were born in the United States. All of my great grandparents came from what is now Ukraine, and my grandmother told me that they were all horse thieves there. So I'm not sure whether I'm insulted or honored by your hypothetical. But no, I essentially agree with all of that. And I, in some sense, the one worry I have is that one or more justices might try to split the difference and to say that the order is invalid with respect to children born to parents who are lawfully present but not permanent residents or citizens, but valid with respect to people who are unlawfully present, notwithstanding your view about what that would have done to people who were enslaved. Partly that has to do with, there's a way to arguably distinguish Wong Kim Ark, although the immigration laws at the time were very different, so it's not even clear what it meant to be lawfully present. So I share your confidence about the bottom line. I'm not entirely sure it'll be unanimous with respect to both provisions, but
so Mike, really quickly on that, they could say that in dicta. I hope they don't. But for reasons I explain in a verdict column, the way the order is crafted, the way it's written, incredibly badly, like everything else this administration produces, the writing is terrible. It would be impossible to sever the two aspects of this order, because that would create a gender classification that would treat biological mothers differently than biological fathers because of the inartful drafting.
Yeah, that good point. And I'd also say that, even if you just have it apply prospectively, it does create incredible problems because, right, if we go back to your hypothetical, so it doesn't apply to me, but it applies to, my children's children who are going to be born after the order went into effect. And there was a great piece on my blog by Jacob Hamburger a few months ago about the way in which state and county hospital record keeping is not set up to deal with this, so that it would be almost impossible to prove one citizenship. Okay, I'll stop there so we can get on some more cases. Well, you're talking about Calais now, I think, right?
Okay, I'll talk. I'm going to talk briefly about Calais, and then the tariff case. I'll just say a couple of words of that, and then I'll come back to you for the transgender cases and the Colorado case. You can close with those. So Calais is a carryover case from last year involving Louisiana's congressional districting. After the census, Louisiana redrew its district lines. Civil rights advocates thought that there were too few districts in which Black voters were likely to elect the candidate of their choice. They sued under the Voting Rights Act. Louisiana went back to the drawing board. They redrew the districts in a way that increased the number of districts in which Black voters would have a good chance of electing the candidate of their choice. And then conservatives sued and said, no, you took race into account in a way that's problematic. Court had it on its docket last term. They decided to have the case re-argued, and they sought input on the question of whether the Voting Rights Act, to the extent that it allows race to be considered in the drawing of congressional district lines, or for that matter, I guess, state district lines, might violate the 15th Amendment or anything else in the Constitution. So this is a full frontal challenge to the idea that the Voting Rights Act can do anything other than prohibit affirmative racial discrimination. Can it remedy de facto or disparate impact discrimination against racial minority groups? And that's a huge question. Two things I have to say about that. Notice that to the extent that Louisiana took race into account here in drawing the district lines, it's not taking race into account at the individual person level the way that was involved in SFFA, the affirmative action cases. This is letting racial statistics and racial generalizations inform the criteria that you use, in this case, the geographical areas that you draw the lines. If race cannot be used to draw district lines at all, then I don't know that race could be used to pick criteria for university admission. So, for example, if a university says we're going to get out of the business of standardized testing precisely because it has such a racially disparate impact, that too would be race conscious in a problematic way. Now, it may be easier to prove race consciousness in the districting arena because there are, quote, traditional districting principles whose disrespect suggests that something else, i.e. race, might be at work. But query whether you can say the same thing about admissions. Is it a traditional admissions criteria to use standardized testing such that your deviation therefrom suggests that something else, i.e. race, was at work? So I think this is a big question about how colorblind we're going to be, extending beyond the formal colorblindedness of the SFFA cases that applies when race of an individual is used to determine receipt of a benefit or imposition of a burden. The other thing I'll say about this is just a few terms ago in Allen versus Milligan, the Supreme Court rejected a claim that the Voting Rights Act violates the Constitution because it permits race to be taken into account. And the court cited City of Rome for the idea that the 15th Amendment allows Congress to remedy disparate impact and not just disparate treatment racial discrimination. So I don't know. I mean, I know this is a court that doesn't feel super bound by precedent, but it's weird that they just said that a few years ago in an opinion by Roberts, no less. So those are the two thoughts I have about Calais. Now,
Yeah. So you
jump in on that.
I was supposed to say one word about Calais. So, one of the things that I think your parsing of the case implicates is this distinction between racial classifications and race-conscious decision-making. And I think the best example of that in the court's cases over the last 20 years is a concurrence by Justice Kennedy in Parents Involved against Seattle Community Schools, in which is the case in which the majority says that a school district that isn't on the hook for de jure segregation is not permitted to voluntarily assign students by race, even as a sort of secondary factor. Justice Kennedy agrees with the result, but he parts company with the majority, and he draws a pretty sharp distinction between racial classifications and this idea of taking race into account in formulating other kinds of criteria. And I'm not sure that principle survives in this court, right? As you're saying, this is implicated by some of the post-SFFA cases. I have a recent law review article in the Texas Law Review on the extent to which this remains possible. I think it's still technically an open question, but I'm worried that the court is going to equate all race-conscious decision-making with race-based classifications.
I agree with you. And then the big question is, how easy is it to prove kind of pro-minority racial mindset? And then I'll call you Justice Kennedy and raise you Justice Thomas, because remember, in the dissents in Grutter, Thomas said, well, if Michigan wants diversity, the Michigan Law School affirmative action case, he says they could just, if they want diversity, they can just have a lottery instead of using the LSAT. They don't need to be elite. They can just admit people randomly for the precise purpose of having a representative student body. So he's done a 180 on this in the Thomas Jefferson High School case. So what he said in Grutter, he no longer believes either. So I agree that the majority is likely to do that.
Yeah, the lottery is my primary example in the Texas Law Review article. So do we want to talk next about tariffs? Or you want to go to my cases?
Let me just say 2 words about tariffs.
Yeah.
This is not a case about whether the federal government can issue the tariffs. It's a case about separation of powers and whether the president can unilaterally impose these very aggressive tariffs on all these countries under a particular statute, the IEEPA, International Economic Emergency Powers Act. And in a lot of cases in the last 5 years, the Supreme Court has developed something called the Major Questions Doctrine, in which it has said that if the president is exercising really broad, impactful authority that involves major questions of monetary and political and economic significance, he can't do it without more explicit congressional authorization. This is a kind of a second best effort to vindicate the non-delegation idea that Congress should be making the basic policy choices and not the president. And if we can't police the line between permissible creation of executive discretion on the one hand and impermissible delegation of legislative power, at least we can require Congress to speak clearly before we allow the president to get close to that line. I've developed that theory I developed the constitutional foundation of the major questions doctrine in an amicus brief in the D.C. Circuit and the Federal Circuit in the tariff case below. But that's going to be the question, is whether the court follows through on cases like Biden versus Nebraska student loans, where they said Congress hadn't authorized it explicitly enough, West Virginia versus EPA, et cetera. Now, there's two people to watch here, because I think Roberts will actually be with the Democratic appointees on this and say Congress hasn't spoken clearly enough. You can't do it. That's my instinct. But it's going to come down to Barrett and Kavanaugh, perhaps. Now, Kavanaugh, in his concurrence in last term's non-delegation case involving the FCC, he too invoked the major questions doctrine as a kind of a poor person's way to vindicate the non-delegation idea. But he observed that that idea applies differently when we're talking about foreign affairs or national security. So for Kavanaugh, the key question is going to be, do we see this tariff case as domestic taxes or international affairs? And I think the clearest kind of precedent on that is the steel seizure case, Youngstown, where Truman argued that, look, I need to take over these steel mills because I need to have steel to prosecute the foreign policy and the Korean War. And the court shut that down, saying, no, this is a domestic theater. Everything has relationships to foreign affairs. And so, but for if I were trying to capture Kavanaugh's vote, I would really have that frame in mind, that dichotomy in mind.
Yeah, I think I agree with all of that. Justice Barrett has also said that she thinks the major questions doctrine is not a so-called substantive canon, but is just an interpretive canon, meaning it's not pursuing this additional policy of a kind of backdoor non-delegation doctrine. It's just trying to figure out what Congress was intending. But I think that the text of the statute is pretty good for the challengers, because there are lots of other statutes that explicitly give the president tariff authority. This one doesn't. This one is about economic emergencies. It reminds me a little bit of the two vaccine mandate cases that the court heard during the pandemic from the Biden administration. And you'll remember that the court upheld the HHS mandate, basically on the theory that, well, hospitals, that's something that where this is within their wheelhouse, but invalidated the OSHA mandate on the theory that, people can get COVID at the workplace, at home, when they're out in public. It's not about workplaces. Now, there was a dissent saying, well, the language doesn't exactly track that. But at a sort of broader level, if the justices are thinking about what was Congress trying to do here, it's very hard to imagine that, just playing it straight, you would say Congress was trying to give the president tariff authority of the sort that President Trump has exercised.
Now, of course, that doesn't mean that some of the tariffs out there aren't grounded in other statutes, and or that a Republican Congress might give the president the power that he seeks, although that's one issue where the Republicans in the Senate are not necessarily eye to eye with the president on this tariff stuff. So why don't we let you take us home with the Colorado case and the two transgender athlete cases, which have some connections to each other.
Sure. So yesterday, the Supreme Court heard oral argument in a case called Childs against Salazar. So Colorado, like a number of other states, bans so-called conversion therapy. Ms. Childs said that she is a licensed counselor under the Colorado law, and she wants to be able to advise her minor clients if they come to her asking, how can I live in a way that's I don't want to be gay anymore. I don't want to feel like I'm dealing with gender dysphoria, but I don't want to transition. She wants to be able to advise them in those directions. There's a threshold question in the case of whether Colorado's law even applies. In its brief in opposition to certiorari, Colorado had a whole argument saying that she lacks standing because their law doesn't apply to her. They relegated that to a footnote in the merits brief because the court granted cert. Justice Sotomayor was very interested in this question yesterday, but almost nobody else seemed to buy it. So I'm very confident that the court will reach the merits. And the merits are a free speech objection. She says, look, I'm just providing talk therapy. That's a kind of speech. The Supreme Court said in the case Nifla against Becerra a few years ago that there's no professional speech exception to the First Amendment. Colorado says, well, no, that's not true at all. We're regulating your conduct, your therapy, that happens to be provided through speech. So if I can give an analogy, right? If somebody sold a pill that was really just a sugar pill or worse, contained some sort of dangerous toxin and said, this will turn people from gay to straight, certainly the government could regulate that without implicating any individual rights of the doctor to, dispense what is essentially, quackery. And they say, Colorado says, well, you can't do that through talk therapy either. Based on the oral argument, it looks very much like there is a majority, including possibly Justice Kagan as well as the conservatives, to say that this challenge succeeds in the sense that you have to apply strict scrutiny to the Colorado's application of its conversion therapy ban. And interestingly, there was a lot of discussion of what Justice Gorsuch called a mirror image law. So he imagines that Tennessee, following up on the Scrimeti decision, amends its statute so that it doesn't just apply to puberty blockers and hormone therapy, but also applies to gender-affirming talk therapy. And he asked, what is the implication of your respective theories for this? And interestingly, to my mind, all of the lawyers bit the bullet. That is to say that both the lawyer for Ms. Childs, the Deputy Solicitor General arguing for the United States as amicus, said, well, that would be subject to strict scrutiny as well. And the lawyer for Colorado, it took her a long time to get there, and she was not exactly clear about this. It was like 10 excruciating minutes of exchange with Justice Gorsuch and Justice Barrett, but she eventually seemed to say, yeah, that's going to stand or fall together. But the application of strict scrutiny might be different because there is good evidence that conversion therapy doesn't work and is harmful, and that's not what the evidence would be with respect to gender-affirming care talk therapy. Do you have anything you want to jump in on that, or should I go on transgender athletes?
I guess the only thing I'd say is, I wrote a verdict column a while ago saying that states have the power to ban conversion therapy as regulation of professional conduct. But I guess the more I think about it, it's a hard issue for me because so many professions involve speech, and the government can redefine profession anytime it wants. Can it say, for example, anybody who teaches needs a license, and if you get a license to teach, that means you can't teach A, B, or C without implicating the First Amendment. So I think it's more challenging than I used to think it was. Although I do think that the fact that quackery, as you put it, is taking the form of communication cannot immunize it from governmental regulation. And then the question is, well, what does strict scrutiny mean? And is strict scrutiny going to devolve into this kind of ad hoc, result-oriented, I like this law, I don't like that law? One of the things I thought was intriguing in oral argument is some of the justices said that the science that would be used to satisfy or defeat strict scrutiny itself has become politicized in some ways. So how are we going to even evaluate the objective strength of the government's interests in these settings? So I think it's a challenging set of questions.
Yeah, I agree with that. I also think it's a hard case, and I've undergone the same evolution that you have. So your colleague Ash Bhagwat and I both signed on to an amicus brief in defense of the Colorado ban in the lower courts. But then as we sort of thought more about it, especially in the wake of Scrimeti, we didn't sign on for the Supreme Court amicus brief. I mean, I'm not on the other side, but I think I'm ambivalent. Okay, let me talk about the transgender athletes cases. So there are two cases before the court, one from Idaho and the other from West Virginia, involving state bans on transgender girls and women participating in girls and women's sports. The case out of Idaho involved only an equal protection challenge by the time it got to the Ninth Circuit. The case out of West Virginia involved both equal protection and Title IX, which is the federal civil rights law that applies to recipients of federal funds and generally forbids sex discrimination. And the challengers, who are trans female athletes, won in the lower courts in both cases. Although I should point out that the challenger in the Ninth Circuit case, the case out of Idaho, has now said that this whole thing is too much of a headache for her. She doesn't want to participate in sports at all. And so she's filed with the court a suggestion of mootness. That is that, she's not interested in any relief that she can get. The government is opposed to the dismissing the case as moot. I don't think it ultimately matters all that much because they can probably do whatever they want in just the West Virginia case if they have to. But in any event, those are the issues that are teed up. Let me say a little bit about the arguments. So in both the Fourth Circuit and the Ninth Circuit, there were prior cases that had held that laws that discriminate on the basis of transgender status trigger intermediate scrutiny. And so both of those courts applied those precedents. They also said that laws that discriminate in this way are sex discriminatory, partly for a kind of technical reason, which is that the law, as the law is written, it forbids transgender female athletes from participating in women's and girls' sports, but doesn't forbid transgender male athletes from participating in men's and boys' sports. I don't know how effective that argument is. I think that would come out in the wash once you apply whatever level of scrutiny you're going to apply, because the motivation for these laws, or at least the motivation other than, transphobia, the motivation that, would have something to it, is that people who are assigned male at birth, especially if they go through male puberty, have certain biological advantages that gives them unfair advantages in competitive athletics. In any event, the government argues in each case, and the United States has filed an amicus brief on behalf of the Idaho and West Virginia. The government argues in each case, this actually isn't discrimination on the basis of transgender status, saying, well, we're just saying that, what we care about is whether you are a, quote, biological male, which is, in a way, it's a kind of trans erasure, but it's also their way of saying don't even get to the question of what level of scrutiny applies. I don't think that's a persuasive argument. I don't think the court will find it persuasive either. And for that matter, even Justice Alito in the Scrimeti case was dubious of the majority's determination that the Tennessee law in that case didn't discriminate on the basis of transgender status. He thought that if it did, that's okay because you only apply rational basis scrutiny. But that seems like a kind of, fancy footwork. So these cases, I think, if you assume the court's going to reject the government's argument that this isn't even transgender status discrimination, these cases tee up the question that the court ducked in Scrimeti, which is whether laws that discriminate on the basis of transgender status are subject to heightened or intermediate scrutiny, either because being transgender is itself a suspect or semi-suspect classification, or because, as the Supreme Court said in the Bostock case under Title VII, discrimination on the basis of sex, of transgender identity, is discrimination on the basis of sex. The Justice Gorsuch, who was the author of the Bostock opinion, quite sort of obviously didn't ask any questions or write separately in Scrimeti, so he's sort of a cipher on that, although he has said in other contexts, in particular in SFFA, that federal civil rights statutes don't necessarily mean exactly the same thing as what the Equal Protection Clause means. Here, of course, in the West Virginia case, you've got both Title IX and the Equal Protection Clause. And so it's sort of hard to dodge the Bostock logic unless you want to say that the law applies differently, that Title IX is different from Title VII. There's not a terrible argument for that. After all, Title IX, through longstanding regulations, has been construed to permit having separate men's and women's or girls and boys athletic teams. To my mind, I, you know, I wish the court would just apply intermediate scrutiny, because this is one of the contexts, unlike employment, right, where the in Bostock, the transgender plaintiff was working in a funeral home, and so that was just obvious discrimination that was gratuitous. But in the context of athletics, there are arguments, at least for some restrictions, on transgender female athletes participating in at least some competitive sports because of the underlying advantages that male puberty confers in some of those sports. Unfortunately, I don't think that's how the case is going to be decided. It's interesting to note that in the West Virginia case, the Fourth Circuit actually denied summary judgment to the plaintiffs because they thought that, at least on the equal protection claim, you needed some evidence about what advantages are conferred and what advantages are not conferred. But I'm afraid that they're not going to sort of, go through that in a sensitive way, sport by sport, and which is probably the way it should be done. But they're just going to say categorically this either, this either is or is not subject to heightened scrutiny. And I should say two justices, Justices Alito and Barrett, are already on record saying from Scrimeti that they wouldn't apply intermediate scrutiny.
I agree with all that. The results in Scrimeti and the likely results in these cases don't necessarily offend me as much as the intellectual dishonesty in the doctrine that's going to be applied. One quick thing about the Idaho case, as I wrote with my friend Jason Mazzoni on Verdict, there's a strong argument that that case is mooted because the plaintiff has disclaimed any ongoing interest in participating in sports in Idaho, and she sought only injunctive relief. So I think there's a very powerful case that argument that case should be mooted. And on the question of justiciability, let me just mention one other case that was argued today because I think it's interesting and important. It's a case out of the Seventh Circuit involving a candidate's challenge, a congressional candidate's challenge to a state law that permits ballots to be counted when they are postmarked by Election Day but received thereafter. So the Fifth Circuit in a Mississippi case invalidated a similar Mississippi statute on the ground that it conflicted with the federal statutory definition of Election Day. I think a preposterous Fifth Circuit ruling on the merits, and the court has that issue pending whether to grant cert on that on the merits. But in Illinois, a candidate filed a similar challenge, and the Seventh Circuit said he didn't have standing because he didn't have a sufficiently concrete injury since he was going to win or lose the election regardless of whether these votes were counted. And I think that the court, based on press accounts of the argument today, is going to be receptive to his standing argument. I think I say that people like him should be able to challenge these rules, which I think is a good thing. I think, which is why the ACLU and other liberal organizations actually who disagree with his merits claim, the way I disagree with his merits claim, and I've written about that on Verdict as well, think he should be able to have standing because, as Evan Kamaker and I wrote in an Illinois Law Review article last year, justiciability has to be more flexible in election-related cases so that we have an opportunity to actually adjudicate the legality of election logistics before an election. So things like standing and rightness and capable of repetition yet evading review and mootness, they need to be applied in a distinctive manner in this setting. Otherwise, we have elections that are held under a cloud of constitutional doubt, and that's no good for anybody.
Yeah, I would agree with that. Unfortunately, we sometimes have this problem that election laws challenges are like avocados, right? Which is there's like this long period when they're not ripe, and then all of a sudden they're rotten, and they're not edible in between.
And that's exactly the problem that Evan and the Purcell principle that says you can't bring the case too close to an election kind of narrows that window even more, which is why I will actually be happy if the court uses some broad language about facilitating challenges to election laws before the election occurs.
Okay, well, there's lots more on the court's docket, but it looks like we're out of time. So we're going to turn it over to Nina to give you your opportunity to get CLE credit. And thanks for listening. As always, Vic, it's a pleasure talking with you.
Ditto.
Wonderful. Thank you both so much. Always such a pleasure to hear your thoughts and insights. We really appreciate you coming back and being here with us. Now, I know we went a little bit over time today, so unfortunately we don't have time for questions. So we want to thank you all so much for joining us today for another Justia webinar. As I mentioned at the top of the presentation, in the spirit of staying up to date with the latest developments in the courts, we also wanted to remind you of a great free law resource that you have access to as a Justia Connect member, which is our Justia Daily Opinion Summaries. You can select the practice area and jurisdiction of your choosing to get free next day alerts summarizing opinions straight to your inbox. If you'd like to go ahead and sign up for those, you can go to newsletters.justia.com to stay in the loop. Thank you all so much for joining and have a wonderful rest of your day. Thank you very much. Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please click the like button and subscribe to our channel for more videos on law practice and legal marketing. See you in our next video.